Hello, Brian Weeks here again with another MMCD contract consideration. This short video clip will cover the topic of the problems with biased contracts. As you can see, I have been involved with the MMCD Association and its predecessor since 1992 in a number of roles. I was first volunteered to be a contractor representative in the working group which created the general conditions and other front-end documents. I absolutely believe in fair contracts and have made a side career of promoting the MMCD through training and committee work. It has been a while since I did the last contract consideration, and this one will repeat some of the concepts reviewed in earlier ones. The rationale behind the need for this one is that over the past few years, we have noticed a disturbing increase in the contract language which undermines the core principles of the MMCD. This has the potential to return to the bad old days before the MMCD, where there were more disputes and more requirements to settle in court. We hope this video will encourage reconsideration of these biased supplementals. In an effort to reverse this trend, or hopefully halt it, this contract consideration is aimed at all those who draft and approve contract language. Specifically, I hope this video will reach municipal project managers, municipal procurement officers, municipal risk managers, municipal lawyers, municipal chief administrative officers, and consultants who prepare contract language for municipalities. The intent of this video is to explain that the MMCD has been successful because of its fairness and appropriate risk transference. Supplementals, which move away from these principles, undermine the effectiveness of our contract documents, which have proven to be successful over 3 decades. I think it would be useful to review how the MMCD came into being. About 1990, a tripartisan group was formed called the Joint Municipal Committee. The 3 parties sent representatives from the Municipal Engineers Division of the Association of Professional Engineers, the Consulting Engineers of BC, and the BC Road Builders and Heavy Construction Association. As you can see, these participants represented the owners, consultants, and contractors who were involved in municipal contracts. The reason these groups came together was a mutual recognition of the fact that too much time, money, and effort was being wasted by all fighting claim disputes in court. Now, court battles over municipal contracts were not unique. Over preceding decades, BC had a troubled history of biased contracts leading to significant court judgments with regard to contracts from BC Rail and its predecessor, the Pacific Great Eastern, BC Hydro, and the BC Ministry of Transportation, to name some of the bigger owners. Many of these cases were the result of biased contracts, inappropriate risk transference, and unappealable decisions from contract administrators and owners' project managers. Over time, and partly as a result of significant court judgments, these owners began to modify their standard contracts to remove or alter clauses that were causing these problems. Because these owners reported benefits from their revised contract language, municipalities were willing to participate to standardize contract language and remove most of the troublesome clauses to see if they could benefit too. The Joint Municipal Committee started by producing a set of standard specifications, which would form the core elements for participating municipalities. The second stage was the preparation and promulgation of a set of standard detail drawings. Then, in 1992, the Phase 3 subcommittee was developed to create standard tendering and general condition clauses. This subcommittee was given the mandate that the contract language to be developed should be based on the following 6 core principles. Number 1, be fair to all parties. Fair contracts get better bidders and reduce disputes. 2, minimize risk-taking by the contractor. Shifting risk to the contractor that it cannot manage only increases owners' costs. Where risk is transferred to the contractor and the risk does not occur, the owner has paid a risk premium for nothing. Yet, when the risk exceeds the allowance, costs will be incurred by both parties. 3, provide equitable dispute resolution. We know there will always be differences of opinion, but they don't need to result in court cases. For this reason, we created a robust dispute resolution protocol and made the CA impartial and only the initial decision maker. 4, provide equitable change management. All of our projects have changes, so we want to be sure that there is a clear and fair way to implement the changes and deal with their consequences, including payment and time extensions. 5, use plain English. The people who have to implement the contract need to be able to understand it without needing interpretation by others. Number 6, say it once. This ensures that the document is easy to edit and avoids problems when a topic is dealt with in multiple places with slightly different wording. As with the other subcommittees, this one was made up of a balance of representatives from the 3 parties. As mentioned, I was one of the 2 contractor representatives. This was a challenging task that took over 3 years to bring to fruition. In 1995, the original Red Book was published, which consolidated the work of all 3 subcommittees. It was at this point that the Master Municipal Construction Documents Association was formed to publish, promote, and continually update this new document. The reason it took so long was that each proposed clause was reviewed and revised by the subcommittee multiple times until all representatives could accept the draft. No clause was finalized until it was acceptable to all members. As a result, the final language was a blend reflecting the points most important to all members. Having these 3 perspectives was most useful and was, in my opinion, the reason for the MMCD being such a successful document. At last check, in over 28 construction seasons, no MMCD contract disputes between a municipality and a contractor had been taken to court for settlement. Also, having the 3 parties represented helped ensure their sponsoring organizations would have confidence that their opinions had been considered and their needs addressed. This motivated acceptance by most municipalities, so that now the MMCD is the contract template of choice throughout BC in its niche application. To start with, I'd like to address the matter of biased tendering conditions. Numerous owners have moved away from public openings for reasons of convenience to themselves. This lack of transparency and public oversight is not only contrary to the good of society, but also leads to the potential for public malfeasance. In 2011, the Charbonneau inquiry into corruption in public procurement in Quebec found that there had been extensive evidence of bid rigging, bribery, collusion among bidders, kickbacks, and even criminal involvement. While no one is saying that this is happening in BC, it is our association's position that every possible means to add clarity and public oversight should be taken to avoid even the impression of secrecy when awarding public contracts. Returning to public openings would be a very good step in the right direction. Beyond that, some owners have added biased tendering clauses. At least one owner has added a supplemental instruction to tenderers which allows the owner to negotiate changes, additions, and deletions before award with any bidder without advising the low bidder or any other. Another has included the right to cancel without further explanation and accept any tender the owner considers to be in any way advantageous to it. This turns the call for tenders into a request for proposals, providing no protection to the bidders who have spent time and money to tender. Both of these examples clearly open the door for malfeasance. The MMCD Association has published recommendations allowing for very limited pre-award negotiations with the low bidder only, and only for scope reduction when the low bid is beyond the owner's budget. Let me review the MMCD principles of risk management. First, the owner owns all of the risk at the conception of the project. The owner then decides which risks will be sold through the tendering language. Getting someone to accept your risk is never free. Second, the only risks which should be transferred to the contractor are those which can be better managed by the contractor than the owner. For example, schedule management, timely, cost-effective material procurement, and selection and management of subcontractors belongs with the contractor. On the other hand, risks due to unforeseen ground conditions or the discovery of hazardous materials can be mitigated by the owner doing more geotechnical investigations before tendering. What I'm seeing recently is many contracts where the owner attempts to reduce costs by doing or authorizing insufficient pre-tender site investigation and accepting or commissioning incomplete detailed design and/or survey drawings. They're attempting to compensate for these inadequacies by making the contractor responsible for either doing those tasks or accepting the consequences without recourse to recovering the resulting costs. For example, one owner has a clause that says, quote, "The contractor acknowledges and agrees that it has conducted its own independent investigation and has taken into account the risks of concealed or unknown conditions." Consider that the contractor has only 2 or 3 weeks to bid a tender, while the owner and consultant may have taken 1 or 2 years to tender the project. Yet, somehow, the owners believe that the contractor has time to complete an adequate investigation. Is this even reasonable? Well, not only is it unreasonable, it's also impractical and undesirable to have all bidders each conduct their own site investigations before tendering. Just imagine multiple geotech consultants digging holes down Main Street during the tendering period. Furthermore, the BC courts have already determined that this requirement is impossible to meet, and therefore it becomes unenforceable. Hence, owners cannot rely on such language. This leaves the owner in a worse position than if they had not attempted to shift this risk. Besides which, what would give one the idea that it would be cheaper to have the contractor sub out the geotechnical study and then mark up those costs when tendering, rather than having the owner engage the consultant directly in the first place? But if you insist on attempting such risk transference, good legal advice is essential. I need to define what we consider is a biased or unfair clause. In short, biased contract language violates one or more of the guiding principles of the MMCD, which I just reviewed. They invoke clauses which transfer risk to the contractor, which should have remained with the owner. These are risks that the contractor cannot manage, so the contractor must include risk allowances which would not be present if the owner had retained that risk. For example, unforeseen site conditions, such as geologic changes, hazardous material discovery, unknown and mislocated subsurface impediments, utility relocation, force majeure, unforeseeable market adjustments, such as the unavailability of some materials, uncompensated responsibility for incorrect or inadequate design and the resulting necessary changes, refusal to pay for increased costs due to delays or project extensions. Now, it does not matter if the owner cannot manage a particular risk any better than the contractor. Shifting the risk to the contractor only guarantees an increase in project costs with no guarantee of any benefit to the owner. Other biased clauses reduce the protections built into the MMCD, which enable contractors to include smaller risk allowances. Some clauses I've seen return the contract administrator's role as the final judge without any recourse to appeal. This is a major departure from our contract language and is of great significance. It's vital that there is some method to appeal a CA's decision. Or remove quantity variation protection. Or remove reviews of quotes for changes when circumstances have changed enough to warrant it. Or remove the protection for discovery of unexpected hazardous materials or unknown subsurface obstructions. Some bias clauses add responsibility to the contractor for site investigation. For example, identifying all subsurface utility locations, whether or not included in the tendering information or not located where shown. Having geotechnical studies done by the contractor after award, as I discussed earlier. Some clauses eliminate any ability of the contractor to rely upon any of the tender information provided. Some make the contractor liable for any costs resulting from inaccurate or incomplete design information. Some make the contractor liable for all site hazards, whether or not identified by the owner, as is required by WorkSafe BC. Some clauses eliminate certainty of payment for change orders, even those authorized by the CA, by making them subject to the owner's ability to pay. This should be ascertained by the CA prior to issuing a change order, as one of the guiding principles in the MMCD is that the CA's signature is good as gold, meaning that once the change order is signed, the contractor can do the work knowing it will be paid. This means it's up to the CA to get that approval before signing the change order. At least one clause provides penalties for missing milestones, but no offsetting bonus for early completion. Once again, not only are such clauses counterproductive, to avoid trouble, you need to have them reviewed for legality. The proliferation of these biased supplemental clauses undermines the basis and intent of the MMCD. They're starting to take us back to the bad old days of 50 years ago. Let's consider the consequences of such biased contracts. Firstly, they're costing owners money. Here are some ways. Number one, fewer best qualified bidders are interested. One major contractor went public to say they would no longer bid work in their home municipality because of the biased supplemental terms. But he was the exception. Most contractors don't go public. They just quietly look for bidding opportunities where they'll know they'll get a fair contract. Owners have no way to tell how much this has cost them. Those that do bid higher to provide contingency funds for the risks that are being transferred to them. As all bidders do this, the average bid price is higher than it would be otherwise. But again, owners have no way to quantify this. 3, more desperate or inexperienced bidders may not price sufficient contingency funds to cover the risks. When they get into difficulties on the job and start to lose money, several consequences may occur. More disputes and claims arise. More requests for change orders are filed. Potentially, quality suffers. Relations between the contractor, CA, and the owner inevitably deteriorate. And in the worst case, the contractor goes into bankruptcy and the owner has to deal with the bonding company to restart the now delayed project with another contractor. 4, all of the above consequences increase contract administration time at both the field level and within the municipality. Firms providing CA services will bill more for their increased time. This cost is measurable and adds to the overall project cost. Owner staff time will be diverted from more productive work to deal with these issues. This cost, which may be the most significant, is immeasurable and is never attributed to the project. These consequences are the reasons the three parties came together to develop the MMCD in the first place. It seems we've forgotten that. The reason the parties came together in 1991 was because they all realized the then current contracts were costing everyone money and there had to be a better way. In other words, those involved at the time knew the consequences of bad contracts and were motivated to fix the problem. Now, some 30+ years later, many of those old hands with their institutional knowledge have retired or moved on. I speculate the current incumbents have little or no knowledge of how litigious things were before the MMCD. In effect, they have benefited from the work and decisions of their predecessors, but are now under pressure to reduce risk to the municipality. In attempting to do this, there appears to be no recognition that transferring unmanageable risk to the contractor may look good on paper, but in reality, this only increases costs to the owner. As I stated, only some of the increased costs are measurable, many are not. Hence, the motivation to correct the problem is reduced or delayed. It is the position of the MMCD Association that owners should reconsider any supplementals that divert from or undermine the basic principles of fairness upon which the MMCD was created. Specifically, return to shifting only those risks that are better managed by the contractor. Leave in place clauses that protect the contractor against quantity variation situations, hazardous material discovery, unforeseen condition discovery, force majeure for unforeseen and unforeseeable events and market changes, costs for delays when utility companies contracted to the owner failed to meet their commitments, and termination of prime contractor responsibility at substantial performance once the site reverts to total control by the owner. Now, I don't have time in this video to discuss supplemental specifications, but we have seen many of our principles being undermined there as well, particularly with regard to inspection, remediation, and payment. Please consider that my comments on biased GC supplementals also apply to supplemental specifications. Additionally, owners should never alter the role of the CA and the ability of the contractor to file a dispute when in disagreement with his or her initial ruling. Having the CA make a final and binding decision was one of the prime causes of many past court cases. The MMCD carefully defined the scope and limitations of the CA's role, which has worked very well over several decades. Most importantly, the CA is obliged by the contract to be impartial when evaluating the performance of both parties to the contract. Furthermore, the MMCD has carefully developed a protocol for starting and resolving a dispute. Once a dispute is properly initiated, the CA's ruling will be reviewed by others. The matter will be resolved by those who do not have to work together on a daily basis for the balance of the project and who will have less ego involvement in the eventual resolution. To summarize, number one, biased contracts were the impetus for three parties to collaborate to create a fair and unbiased contract, resulting in the MMCD 30 years ago. Two, in recent years, there's been a proliferation of contracts containing biased supplemental conditions. Three, this has led to some bidders declining to bid and others adding significant risk premiums in an attempt to protect against the increased risks they're being asked to assume. Four, this increases the owner's costs without truly reducing the owner's risk. Five, the MMCD Association strongly urges owners to remove supplementals which are contrary to the original MMCD principles, whether in the instructions to tenderers, general conditions, or specifications. In particular, transfer only risks better managed by the contractor. Spend more money on pre-tender investigations and more complete design to reduce uncertainty during bidding and construction. Train your staff on the benefits of proper risk allocation. Resume public openings and severely limit any pre-award negotiations in accordance with the MMCDA recommendations. Well, I hope that's helped clarify this contract consideration. Please check our website for further assistance and to see what other topics are presented in this series, which now contains over 40 videos. Thanks for watching.